Great.
Okay, so good evening to one and all that have joined us today. On behalf of the Nyaya Forum for Courtroom Learning at Nalsar, we welcome all of you to this Nyaya special webinar, and we thank Justice Chandrachud to take his precious time to join with us today. A little bit about the Nyaya Forum. The Nyaya Forum is a first of its kind student-initiated think tank that has been started by a few students at Nalsar, which is devoted towards research and advocacy in litigation and judiciary as the two routes towards courtroom lawyering. Our guest for today really needs no introduction. Justice Dr. Dhananjaya Chandrachud, currently a sitting judge at the Supreme Court of India. He served as the Chief Justice of the Allahabad High Court and formerly a judge of the Bombay High Court. He's alumnus of the Delhi University and the University of Harvard. Currently, he's been appointed as the chairman of the E-Committee at the Supreme Court of India and is one of the pioneers behind the new E-file procedure that has been just currently launched by the Supreme Court a few days ago. In today's times, in the current pandemic, things are a little uncertain and we don't really know what's the way forward and how we're going to move forward. I'm out to talk to us about the topic of the future of virtual courts in India and the access to justice. We should be taking around an hour for this session. And I'll be taking in a few questions. Is it clear from my side?
Yeah, but I can't see you. There was a little bit of stoppage in the video, but I can see you now on the screen, yes.
So is your camera turned on though?
Yeah, just 1 second. Yeah, now it's turned on. Is my camera turned on? Do you have my video footage?
So I can't really see you right now.
Okay, 1 second.
Okay, sir.
Can you see me now? How is it now? Chotu, ek minute thamba. Yeah, Mustafa, can you see me?
Yes, sir. So really sorry for the...
No, not at all. I mean, in case there's a problem, I'm in my office. I can always go in and there's a Wi-Fi at home. So it's just the office Wi-Fi is much faster, which is 100 Mbps. And but if necessary, just give me, if there's any break, we'll just tell the audience that I'll just go into my residence. It'll take me just 2 or 3 minutes to reconnect and I'll be back.
So do you want to do that right now? We can wait for 2 minutes then.
How is it now? Is it okay?
So it's clear now, so we can see you properly.
Okay, perfect. Then we'll go ahead because I've done it last week. Yeah.
Okay, so we're taking a few questions at the end from the attendees as well, and I'll direct them to you as and when time permits. So that's fine.
Oh yes, absolutely.
Okay, so and we also stream live on YouTube at this point as well, alongside our Zoom sessions. And we have more than around 400 to 500 attendees who have joined in out there. And we have numbers that are rolling in there as well. So without any further ado, so I won't take much of your time now. I'd like to pass on the floor to you.
Okay. Thank you so much, Mustafa. It's truly a pleasure to be on this link with all the students at Nalsar. And I hope that this is going to be a fruitful and interesting session. Mustafa, I don't seem to have you on the video. Do you have me on the video?
So I've just turned my video off for this session, sir.
Okay, great. Perfect.
I'll tune in again once the question answers begin. So just
great. And
so your screen is only visible to the audience.
You have me on the video, right?
Yes, sir, I have you on the video.
The audio is fine. Okay, great. All right, we'll get rolling. Good evening, and thank you very much for joining into this session. As chairperson of the E-Committee of the Supreme Court of India, I think this is a wonderful opportunity to interact with you and to get your feedback on a lot of work that is being done, not just in the Supreme Court, but across 17,000 or more courts in India today. Away from the world of technology, I've been reading a book today by Rebecca Solnit. It's all about her experience as a feminist writer. And the book, which is a memoir by Rebecca Solnit, is titled Recollections of My Non-Existence. And I found a sentence by Rebecca Solnit, which is so true to what we are discussing today, namely that change is the measure of time. Well, let me begin by telling you of two caveats which I have. One, I'm not a soothsayer, nor am I a person from technology. So I'm not quite sure whether I can speak of where technology and our court system will lead us 5 years, 10 years, or 20 years down the line. We know how computing capacity has increased by leaps and bounds. Storage capacity has increased by leaps and bounds. And we are now living in an age of artificial intelligence and blockchain, the new technologies. So I'm not a soothsayer, least of all an astrologer. The second, which I want to tell you, the second caveat, is that the art of persuasion was all part of my life as a lawyer, a profession which I switched over to judging from in March of 2000. So it's 20 years and 2 months. Having said that, though while I was involved in the art of persuasion as a lawyer, I also believe that judges also engage in the art of persuasion because we persuade the community for whom our judgments are met through what we write. And I believe that in the next half an hour or a little more that I'm going to make my presentation for you, I'll be able to make out what I believe is an axiomatic case for a robust, tech-enabled Indian judiciary for the future. Now, the way I've bifurcated or divided my presentation this afternoon is first I'm going to speak of the immediate past, what has happened just 2 months back. The second, I'm going to talk about the e-courts project, because I believe that even today, there is absence of adequate dissemination of knowledge about our e-courts project. The third aspect which I'm going to present to you is about technology as an adjunct of the rule of law, and then speak about the future. And then finally, I'm going to try and lay out my vision in the interface between the Indian judiciary and technology. Let me begin by saying this, that there are three fundamental principles on which we must look at the interface between technology and the judicial process. First, we are looking at technology to enhance access to justice. Access to justice to common citizens who come to the courts for redressal of the injustices which have been caused to them. Second, we'll be looking at technology as an intrinsic element of the rule of law. And third, and I think the third is equally important, that we must look upon justicing not just as a sovereign function, but to my mind in the world of technology as a service which is provided to the community. Now, it probably, for a lot of you and for a lot of lawyers who are city-bred, it would be a self-evident proposition that we need technology in the judiciary. Just one factual statement, between 2017 and 2020, internet penetration in India rose from 437 million to 564 million. By 2021, internet users are expected to rise to 600 million people. So there you have this expanding base of internet penetration in the country, across the length and breadth of the country. Does technology then make its own case? Equally, we must look at the other side of the picture as well. The data of the TRAI shows that internet density in India stands at 52%. 66% of our population lives in villages, only 27% has access to the internet today. 25.3% Indians have access to smartphones. So when we talk about the increasing or widening base of technological coverage in terms of the internet, in terms of smartphones, let's be conscious of the figures today. And we must ensure, I believe, that whether it be the lawyer, whether it be the litigant, whether it be any kind of stakeholder, we must ensure that the technological divide as it persists today is not a means of exclusion, but we must use technology for inclusive justice. Now, having said that, let me begin by telling you what happened in the recent past. COVID-19 descended without a warning, as many pandemics do, as history tells us they've done. Early steps were taken by our court to address the threat of COVID-19. We limited the number of lawyers within the courtrooms, sanitized courtrooms between hearings. We had temperature checking at court entrances and social distancing on court premises. And this is not just the Supreme Court. As chairperson of the committee, I was in constant touch with the chairpersons of all the IT committees of the High Courts, spanning the length and the breadth of the country. But yet, once the lockdown was announced, it was immediately apparent that the functioning of the courts could not be suspended. Access to justice cannot suffer a lockdown, whatever be the circumstances. The criminal justice system cannot function without courts. According to the National Judicial Data Grid data, just about 70% of cases which are pending in Indian courts are criminal cases. I'll come to the NJDG in a moment. The Supreme Court directed the suspension of the limitation period under all general and special laws from 15th March 2020. Yet closing the courts for months could have led to a backlog and delays in the dispensation of justice. Restrictions on economic activity may possibly lead to a reduction in the filing of civil and commercial cases. But yet on the criminal side, delays impact the completion of investigation, the availability and examination of witnesses, and above all, the liberty of accused who are detained as under trials for extended periods. All emergencies, and we are in a public health crisis, all emergencies, including the public health crisis that we are in, vest substantial powers in the executive. During a public health crisis, increased government action may be necessary to preserve public health and welfare. However, and this is the point which I want to make, irrespective of governmental action and restrictions, it is above all the duty of courts, civil, criminal, and constitutional courts, to protect the rights of citizens, to ensure governmental accountability and the rule of law. So immediately we began investigating methods through which courts could function during the lockdown. There was long-standing work which has been done as part of the National Policy for ICT Enablement of the Indian Judiciary, and the e-courts project was put to test. Almost immediately after the lockdown, video conferencing hearings took place, commencing with the Supreme Court and then spreading across the high courts into the district courts. Now, what I want to emphasize at this stage is that it couldn't be possible overnight to switch to video conferencing technology if we did not have a robust infrastructure. The fact that we could switch over to video conferencing technology and to use both the hardware and software, which was at our command, was because of the fact that a robust infrastructure had been created in the past. And over the last several months, when I've been coordinating with the Chief Justices of the High Courts, the chairpersons of the computer committees, and the project coordinators in the district judiciary and the high courts, I've been amazed at the kind of work which is going on, both in the high courts and in the district judiciary. Now, two visible changes took place in courts. First, video conferencing, and second, e-filing. These changes involve substantial behind-the-scenes work, including setting up infrastructure, consultation with stakeholders, training, platform development, and testing. In the Supreme Court itself, as you probably know, we have put out a module for e-filing of cases, which we rolled out on a webinar a couple of weeks ago. We are now inviting suggestions from the bar because we believe that the essence of our success in the mission to incorporate technology will lie in gaining the confidence of every stakeholder, the citizens who have grievances with which they come before the courts, the bar, and our staff. The bar has to be technologically enabled. We have to be conscious of the fact that not all lawyers have the same access to technology, and therefore we have to generate a degree of confidence in the bar, not merely in the metropolitan areas, but in the smaller areas of the country, that technology is something which will enable the lawyer, to be a better service provider. So we created a regulatory regime for hearings over video conferencing, which was vital to the process. The Supreme Court passed orders under Article 142 of the Constitution, and I constituted a committee of 5 judges of the IT committees of the High Courts, judges drawn from Madhya Pradesh, Karnataka, Justice Satish Sharma from Madhya Pradesh, Justice Arvind Kumar from Karnataka, Justice Rajiv Shabdar from Delhi, Justice Sivagnanam from Chennai, from Madras, and Justice Nitin Zamdar from the Bombay High Court, and they were assisted by Justice R.C. Chavan, a former judge of the Bombay High Court who is the vice chairperson of the E-committee. We drew up model video conferencing rules, invited suggestions from the High Courts, and now we have rolled them out for acceptance and implementation by the High Court. So we have a legal regime. Equally important is the creation of standard operation procedures and training manuals for us. Presently, the E-committee is looking at something very significant. We are working on 4 major projects. First, laying down an SOP for digitization. Second, laying down an SOP for e-filing across the country. Third, we are also dealing with rules for live streaming. Fourth, we are dealing with the interoperable criminal justice system, of which I will speak in a moment, the ICJS platform. And actually the 5th, which is the interlinking of law libraries across the country. Now, having said that, let me give you just some indication of the nature of the e-courts project. The signal achievement of the e-courts project is, I think, first and foremost, the National Judicial Data Grid. I have figures which I have downloaded from the NJDG as of 24th of May 2020. I did that this morning. The NJDG data shows us that the total number of pending cases is 32.45 million in India. 9.05 million are civil cases. 23.39 million are criminal cases. Cases which are less than 1 year old are 32%. Those between 1 to 3 years are 28%. Cases between 3 to 5 years are 15%. Cases between 5 and 10 years old are 15%. 10 to 20 years are 7%. And those between 20 and 30 years are 1.28%. Cases above 30 years in our system are 0.26%. Now that just gives you an indicator. Technology tells us which is the part of the pyramid that we have to attack first. First is the priority to deal with over 10-year-old cases. We have details on stage-wise pendency. Last month, during the COVID pandemic, 3,049 civil cases and 90,742 criminal cases were instituted in the country. Our courts disposed of 832 civil cases and 40,095 criminal cases. We have data in the NJDG about pendency at the original, the appellate, and the execution stages. We have pendency dealing with case type pendency, which are the cases which are pending. We have drill down features in the NJDG. The drill down feature allows you to look at the country as a whole, the macro data. You go down to the level of a state, you go down to the level of any one of the 633 districts in the country, and then within the districts, you can drill down to an individual case. We have data on the reasons for pendency of cases. We have data in the NJDG on cases which have been disposed of 27.35 million civil cases and 70.85 million criminal cases which have been disposed of. So we have collected data of 98.20 million cases which have been disposed of. That's 9.82 crore cases. Our alerts in the NJDG give you an indication of today's cases, undated cases, more than 10-year-old disposed of in the last month, cases under objection, cases under registration. We have a section on information management. So we have data for 633 districts covering all the states and union territories. There are 8,230 court complexes in India. 133.24 million pending and disposed of cases are all comprehended in the NJDG, out of which 119.68 million orders have been uploaded in the NJDG. Our data covers 19,794 judicial officers. We have data state-wise on under trials. Now that's a lot of data. And I'll be addressing you shortly on what are we going to do about this data. Having given you this broad picture about the NJDG, I want to tell you briefly about the phases of the e-courts project. Phase 1 of the e-courts project was from February 2007 until March 2015 with a sanctioned outlay of 935 crores. To just give you a bird's eye picture, 14,249 courtrooms, the sites were prepared for hardware and software. 13,606, the LAN was installed. 13,436 courtrooms, hardware installed. 13,672 courtrooms, software was deployed. Video conferencing facilities between courts and jails covering 840 locations. We developed a case information software as part of the e-courts project. It has been developed by the NIC Pune by a very dynamic young officer by the name of Ashish Shiradhonkar. And Ashish and his team developed CIS model 1.0, which was based on the core periphery model, which was installed in all district courts. And data of 2.2 crore pending and disposed of cases was then made available. Now, phase 2 of the e-courts project was launched on 4 August 2015, and it covers 4 years or until the phase is completed at a cost outlay of 1,670 crores. As part of the e-courts project, various initiatives have been taken up. I've spoken briefly about the model rules on video conferencing, which have been now sent out and circulated to the high courts for the purpose of acceptance. Among the critical features of the model video conferencing rules is the principle that all recourse to video conferencing must be available for public access. The essential nature of the judicial process, which is access to the public to a public courtroom, must be preserved in the course of video conferencing. The second important facet of our e-courts project is the customization of the operating system software. You would be interested to know that in this process, in setting up the CIS versions, including CIS 3.0, we've used an open source software using FOSS technology, as a result of which there has been a saving to the public exchequer of nearly 340 crores because we have not used licensed software. We have operated on the Ubuntu Linux platform. I've spoken briefly about the National Judicial Data Grid. We have an e-courts website. Every district court has its own website on which judicial orders are uploaded. The core, the spine of the CIS is the CNR number. The CNR number is attached to a case, the case number record. It's a unique identifier to each case which is pending and which has been disposed of throughout the country. The CNR number can be converted into QR code images. By simply scanning the QR code, the user can get the entire case history of the case. Recently, we have set up E-seva Kendras. We began with a pilot to establish E-seva Kendras in every high court at the principal location and in one pilot location in the districts. Every day I get video images of the new E-seva Kendras which have been set up in the country. The idea of setting up E-seva Kendras is to cover the technological divide. We are conscious of the fact that every litigant does not have access to technology. Lawyers do not necessarily have access to technology. So we perceive as part of the e-courts project that E-seva Kendras should be the focal points where service is provided to the common citizen, to the lawyer, to access those facilities which the e-courts project extends. There are simple features which have been developed, and I wouldn't want to take too much time on this, but I must mention some of them. You have the facility of an SMS push, where the case status is sent automatically to a registered advocate and to litigants through an SMS by the CIS 3.0 software. We have SMS pull facilities for litigants who have no internet connection. So the case details can be obtained through an SMS by sending the unique CNR number to a particular number, and the format of the SMS is also prescribed, and the case details are automatically sent as a reply SMS to the user mobile. The case information software which we have developed for the district courts, and which is CIS 3.2, as I said, is an open source solution. It's based on CNR. It is bilingual, available for Hindi, Marathi, Gujarati, Kannada, and Tamil at present. We have a data health card, which is a feature which is inbuilt in the CIS to reveal the missing data entries. There is a facility in the CIS to hide a party's name, to hide the details of cases where privacy requires that access should not be given to the public, such as in cases of child sexual abuse or matrimonial disputes, where private issues relating to spouses should not come into the public realm. There is a facility for the automatic fetching of trial court data by the appellate court. Among the facilities which we have developed is the virtual court, which I must speak for a very brief while on. The virtual court has been working in Delhi since 26 July 2019, and it has been dealing with petty traffic cases relating to traffic challans. 20 judicial officers used to do the work of the traffic courts in Delhi. As a result of the virtual court, these 20 have been replaced by one judicial officer. 7,32,061 cases have been disposed of, and 89.5 crore rupees by way of fine has been realized. Recently, phase 2 of the virtual courts was launched in Delhi, so that the CCTV images of offending vehicles are captured by the camera. They are sent to the main server. Then the Parivahan data is collected and sent to the user of the vehicle. The user of the vehicle actually can track the offense which has taken place, namely crossing the zebra line or parking in a no parking zone. And that person has the facility to pay up the fine online. If you don't want to pay up the fine online and contest the case in a court, well, that option is equally open to the person. Following the lead which is being given by the Delhi High Court, we have virtual courts which have been set up in Faridabad, in Pune, and now next week, the Madras High Court is going to be inaugurating the first virtual court. A very critical element of the e-courts project is the ICJS, which is the live electronic exchange of data between courts and all elements of the criminal justice system. The object of the ICJS platform is to have one platform for ensuring that all metadata in relation to the administration of criminal justice becomes available to be tracked by every element of the system. So right from the filing of a charge sheet, the FIR before that, every element has to be tracked on the ICJS platform. A pilot study was conducted in the state of Telangana, which was inaugurated on 15 December 2018, and ICJS is now being replicated elsewhere. 60% of the delay which occurs in Indian courts is as a result of the non-service of summons. Now, how do you deal with the non-service of summons through technology? we have developed the N-STEP application, which is the National Service and Tracking of Electronic Process, which is a mechanism under which you provide a centralized process serving facility. So a bailiff goes to the person who has to be served with the summons with a handheld smart device. It is GPS enabled. So the moment the bailiff reaches the place, the location of the bailiff and the house where the service has to be made or the establishment is tracked on the GPS coordinates. A photograph would be taken. A signature would be taken on the smartphone, much like you give a signature for your bank checkbooks, and that would be uploaded directly into the server. The e-filing module, let me speak just for a minute about this. I'm not going to speak at length about the e-filing module, but particularly I would like to emphasize about the Supreme Court e-filing module. The e-filing module, which has been developed for the Supreme Court, represents a whole universe for a lawyer. As a result of the development of the e-filing module, filing of cases before the Supreme Court would be possible on a 24/7 basis. Every case which is filed would be scrutinized online. Defects in the petition would be conveyed online to the advocate with scheduling indicated. Court fees would be payable online. There are facilities for digital signatures and a whole host of facilities which would individualize the service to every individual lawyer. So a lawyer would know, for instance, their cause list. Which are the cases where documents have been filed by them? Which are the cases where documents have been filed against them? Which are the cases which are lying in defects? Which are the cases which the lawyer is working on at any given point of time prior to filing in the draft mode? So a whole lot of features have been developed as part of the e-filing module. Now, we're trying to do the e-payments platform across India so that you would enable the online payment of court fees, fines, penalties, judicial deposits across the nation. And the e-payment portal is being integrated with state-specific vendors like SBI ePay, eGrass, Grass, GGrass, and Himkosh. We've also done other facilities, including training of trainers. It's important, I think, above all, for us to train not just our staff, not just our judicial officers, but our lawyers, because it is important that we need to carry every segment of the legal profession as we speak about the future. We are on the anvil of phase 3, and as I speak about phase 3 in the last part of my presentation this evening, I'll be dealing with some of the issues which I'd like to cover. Let me really say this. How do we conceive of technology, and what do we conceive as the role of technology in relation to our courts? Susan Hood, who is the chief executive of Her Majesty's Courts and Tribunals Service in the UK, said, "Our processes don't need to be as old as our principles. Technology must at its core be about enhancing access to justice. It must be towards enhancing fundamental values of human dignity and equality. Our court procedures are just too tardy, too expensive, and unintelligible to common citizens. Yet we have to also realize that technologies can be disruptive. We have to be soothsayers to anticipate the future, which I am not. But conscious of our limitations, we have to plan for the future. The confidence of litigants in the adjudicatory functions of courts is an integral component of the rule of law. Technology can make our processes consistent, transparent, and effective. In that sense, as Richard Susskind says in his recent book on the future of online courts, technology is an inseparable adjunct to the rule of law. Well, Richard Susskind makes a compelling case for the adoption of technology in courts. And I'd like to share that with you because it has so much of relevance to India. First, despite the rapid evolution of societies in the digital age, court processes are relatively untouched by change, resulting in a disconnect, a denial of justice. Second, global statistics indicate that access to the internet is statistically higher than access to justice. Third, technology should bring about a transformation rather than simply automating conventional processes. Process improvement through automation is a primitive first step. Technology in the judicial system must unfold its true potential. We have today blockchain, artificial intelligence, and algorithms. And the technology at our command today has the capacity for bringing out a fundamental transformation of judicial process. I spoke about open source technologies which we have deployed. Linux was developed by 15,000 collaborators from as many as 1,400 companies. Now, Susskind has spoken of the interface of technology with legal institutions at 4 levels. And I'll focus on that because then that will lead me to the last part, which is my vision for the future. First is the technological interface between dispute resolution and modern technology. Dispute resolution requires that we must get disputes which reach the courts resolved through processes which are open, transparent, and efficient. The second is dispute containment, ensuring that only those disputes which require judicial resolution enter the court system. The third is dispute avoidance, which is to facilitate those processes which ensure that a problem does not reach the stage of a dispute. And the fourth is legal health promotion, which is disseminating knowledge about rights and remedies available so as to empower citizens. So when we talk about virtual courts and the future of technology, let us understand this, that speaking of virtual courts in that sense is only a small part of the interface of technology with the resolution of disputes. There are 4 stages. The top of the tier, or the last part of the tier, is in that sense dispute resolution. But before that, we have to use technology for dispute containment, to apply online mediation, conciliation, dispute avoidance, to facilitate those processes by which people will not allow festering problems or issues to develop into disputes, and to generate an awareness about rights, about remedies which are available in the law. Therefore, to my mind, open justice that we speak of requires that all information and data findings about the courts, as well as court proceedings themselves, should be understandable to non-lawyers. One of the very telling quotations in Susskind's book is that vision without execution is hallucination. And the second is a quote from Lord Dyson, the Master of Rolls, when he said that any system that requires a 2,000-page user guide has a serious problem. I think technology, therefore, has to be a critical element in court design. We must think in terms of design. Design thinking will go hand in hand with business process re-engineering. Design systems must guide users through areas of law, replace court procedures into manageable chunks, and to have an interface with users. The paradox of many legal systems, the US system is one of them, and ours is no different perhaps in many ways, is that many non-lawyers today feel that you have to be a lawyer to know when you need a lawyer. That has to change. Citizens who do not realize that they have an actionable claim ought not to be excluded from gaining access to justice. So our design structure on the basis of technology must enhance the ambit of courts to include dispute avoidance and to provide for dispute containment. by recourse to mediation and facilitative dispute resolution. And this, as the Civil Justice Council report said in the UK, if we are able to do this, this would be a fluoride element in the law, as Susskind calls it, because that was when you introduced fluoride into water and stopped tooth decay. So we'd be able to stop the decay of the system, and that would be a fluoride element in the law. Another very interesting quote which I wanted to share with you is that we should not be afflicted with this disease called appellate courtitis. Appellate courtitis is when you focus only on the courts at the top of the tier. Let's not just talk about virtual court hearings. Let's not just talk about the Supreme Court. The real interface of the citizen is with the district courts, the district judiciary, the civil judge junior division. So let's talk about empowering the lowest court in the hierarchy in the nation in order to ensure that we have a technologically enabled judiciary. In the last part of my presentation, in the next 5 minutes, I want to briefly deal with my vision for the future. What has happened largely as a part of the process which has taken place in the last, say, 13 years in India, is that data which was being fed manually in court records, proceedings, and registers is now being fed on an electronic platform. But that by itself is not sufficient. Merely replacing conventional or manual methods, the thousands and tens and thousands of registers, with electronic feeding of data is not a technologically enabled, robust judiciary. First and foremost, we need to look at process automation. How can we reduce the processes which take place in our registries, not just in the front office, namely the court, but the back offices of the registry? How do we reduce the number of those processes with the use of business process re-engineering? Second, we must talk beyond process automation as well. And we must look at significantly technology as bringing out a fundamental transformation of the true potential of the Indian judiciary. One of the decisions which I've taken in the last few weeks and which would be of interest to the students is to ensure that the eCourts project operates on open APIs, namely the Open Application Program Interfaces. As you know, an API is a computing interface which defines interactions between multiple software intermediaries so that users can extend their functionality in multiple directions. To my mind, open APIs must be resorted to and must be provided not merely to governmental litigants, but also to private litigants, because it is only through an open API process that we can put the data which we have at our command into the hands of people who can work on that data. I began by telling you with this enormous quantum of data which we have in the NJDG. Our question today is, how do we apply the tools which we have in terms of AI, the algorithms? How do we apply the current learning tools, the management tools, to understand this data, to extrapolate this data, to use this data to provide better services to common citizens? But open APIs, to my mind, is a critical element in the eCourts design which we are implementing at present to make our system of justicing as open, as transparent, and efficient as possible. The next aspect which I want to emphasize as part of our vision for the future is that digitization and e-filing must be standardized across the country and in machine-readable formats. We must also provide for an inclusive judiciary, where people who are visually challenged, the hearing impaired, are able to access our data and perhaps become the lawyers for tomorrow, the judges for tomorrow, leading up perhaps to our first judge of the Supreme Court, like Justice Muhammad Yaqub in the South African Constitutional Court. Above all, I think my vision is that we have to create trust and confidence among lawyers and judges. I don't think that we can posit that virtual courts are going to displace open court hearings. I don't think any judge or any expert on technology is going to tell you that. So I want to disabuse people of the impression that virtual courts are some sort of a panacea, a formula, which is a substitute for open court hearings. No. we had no choice in the pandemic but to resort to virtual courts for the simple reason that we had to protect the lives of our lawyers, the lives of our litigants, and every stakeholder who comes to our legal system, to our courts, the media personnel, students, paralegals, lawyers, clerks. So that is why we were initially compelled to have video conferencing virtual court hearings. But what I perceive for the future is a very healthy mix between the use of technology for the purpose of court hearings in areas where we believe technology is well suited, and we must necessarily have open court hearings also, which really constitutes the spine of our system. But equally, let's not really labor under the misconception that we can continue to perform our work in the manner in which work was performed 100 years ago. Whether we like it or not, technology has overcome every aspect of our existence. And as I began by saying, I would be only a soothsayer if I were to tell you that I can understand today fully the ramifications of where technology is taking us. So above all, I want to emphasize that in the e-courts project and as the chairperson of the e-committee, we have to emphasize the need for effective consultation with civil society, the need for effective consultation with lawyers and every stakeholder who is going to be benefited by technology. We have to ensure that our young members of the bar are trained to handle technology, and we must do the hand-holding ourselves. We can't shift the burden to the lawyers themselves, to the young lawyers themselves. I believe as key elements of the justicing process, we as judges have a vital role to ensure that we propagate the interests of society, the interests of the lawyers themselves in adopting modern technology and give them the facilities to be trained in the use of technology. If we do that, we will get the confidence of the bar and we'll get the confidence of every segment of a society. And the values that underlie digitization are summed up in just one phrase, what I call TEST. And TEST stands for trust, empathy, sustainability, and transparency. And when we talk of sustainability, let us also have our belief in the responsibility which we owe as members of the legal profession to the contribution of a sustainable growth and environment around us. I think I've probably said everything that I wanted to, and I'd be happy to now take questions. Thank you very much for your patience and for listening to me.
Thank you so much, sir, for this great address. We have a lot of questions rolled out. So for starters, one of our attendees has asked us about your experience as of now at the Supreme Court with online hearings. How has that been for you? And also has spoken about the aspect of security breaches, which has time and again been surfacing about online conferencing and video calls for hearings. So what are your thoughts on that?
Right. When we started the video conferencing hearings in the Supreme Court, we were using this app called Video. Now, there were certain glitches involved in the app. So far as the high courts were concerned, as the chairperson of the E-committee, I took a call and I said, let the high courts use whatever they are comfortable with. A lot of high courts were using Zoom, but there was an advisory of the Ministry of Home Affairs which pointed out certain issues with Zoom. So I pretty much left it to the high courts to do what they feel is necessary in the circumstances in which different high courts are operating. Now, insofar as the hearings before us in the Supreme Court are concerned, we have operated both from our residential offices at the height of the pandemic, and now that the lockdown has been relaxed somewhat, we are also now having virtual courtrooms from the Supreme Court, where we have our own hardware installed in the Supreme Court. I can tell you that despite glitches, we've been able to conduct business very, very effectively. I've had a 2.5-hour final hearing about 3 weeks back, which was conducted seamlessly. virtual hearings require a considerable degree of discipline. Discipline on the part of the lawyers and discipline on the part of the judges as well. Discipline on the part of the lawyers, because you must allow the person who is in session of the floor, as we say, who is in charge of the hearing at that point, that person should be allowed to complete. Interruption should not take place, and the judge must also be facilitative. You have to ensure that if you have 10 people who are on your screen, that you have to go out of your way to make sure that you have taken everybody on the platform and that everybody has been heard. In the court, you just look up and you know that you've caught the lawyer's eye, and then you call upon the lawyer. Different techniques have to be adopted when you are on a virtual platform. But something very interesting which was said to me by a young lawyer at the conclusion of an argument 2 weeks ago. And that lawyer said that, sir, there's one aspect of technology which I'm sure you may or may not have perhaps thought about, which I must tell you about, and which is that technology is extraordinarily enabling and empowering for young lawyers. Because that lawyer said that when I get up and I argue before you on a screen, and my name is flashed before you on a screen, it makes no difference who is appearing before you, because in a court, necessarily people who are more successful tend to be noticed much faster. It's a technology-enabled screen. Everybody is sharing the same platform. So technology in that sense is a great leveler, which was what a very young lawyer told me. And I thought that this was something which really made an impact on my mind. We have been experimenting with hardware technology so that, both the lawyer as well as the judge would be in the same court premises. We also have software video conferencing where the lawyers could address us from their residential offices. Some of the glitches took place because sometimes the lawyer may not have an adequate bandwidth, but we are finding an answer to that too through the recourse, by taking recourse through a VPN virtual private network. And we are constantly innovating. We are going to be moving very shortly into better technology in the Supreme Court, hopefully in the next few days, so that whatever little glitches that we have seen can be remedied.
Definitely, sir. And also about the part of the technology leveler, I think law students also today who are listening to your address today are also getting to learn a lot at the same level as you. And
there's another aspect which I should have mentioned in response to this question. One of the great sources of, I wouldn't say sadness, but something which we always look upon with something which we wish we could change, is that we want more and more young law students, particularly from the best law schools, to come into the lawyering side of the profession. And I believe that making our courts more technology enabled would make them more attractive to the younger generation, because the future of our courts and the future of the promise which our legal system, the judicial system, holds out would depend on people who are, truly the torchbearers for tomorrow, the young lawyers, the young law students of tomorrow, having the confidence that there is a level playing field in the Indian judiciary. And I think if we pitchfork technology at the appropriate level, we'd make it much more attractive for people who would otherwise want to join law firms to come into the the mainstream justicing process.
So we have another question. This goes on another note. The attendee asks that there is much that needs to be done in terms of infrastructure when it appears to the policy that has been outlined with respect to e-courts. But what does this mean for access to justice in states like the Northeast and Jammu and Kashmir, where access to internet is stymied at the behest of the state?
Look, let me deal with this. I don't want to get into an issue which is a subject matter of a judicial decision by a bench of the Supreme Court. It would not be proper for me to comment on any issue which is either live or which is the subject matter of judicial consideration by the Supreme Court. But let me take the issue of the Northeast. I've been talking to the Chief Justices in the Northeastern states. For instance, I've been talking to Justice Ajay Lamba in Guwahati. I've been talking to, I've been having correspondence with the other Chief Justices in the Northeastern states. And I believe that if we use technology, it's a misnomer to say that we'll not be able to use technology in the northeastern states. We will be able to provide robust infrastructure. When I say that we have provided infrastructure, both in terms of hardware and software, that covers the entire length and breadth of the country, including the northeastern states. In fact, as chairperson of the E-committee, when I get a request from any of the computer committee chairpersons from the northeastern states that there is a deficiency which has to be met, we ensure that that is handled immediately so that every one of their requirements can be duly met. And I think it's part of my responsibility to ensure that the growth of technology takes place not just in the larger states, not just in Maharashtra or Karnataka or Tamil Nadu or Kerala or Punjab and Haryana, but across the length and breadth of the country, the larger states, Uttar Pradesh, Madhya Pradesh, Bihar. In the Patna High Court, for instance, the Chief Justice of the Patna High Court was telling me about the number of bail hearings which are taking place on the video conferencing platform. So yes, of course we have glitches. I can't give you paint a rosy picture in terms of how could we not have glitches when we had to suddenly deal with this pandemic. We had installed video conferencing for video conferencing between the jails and the courts, between the jails and the hospitals. And then we had to use this technological infrastructure for running all the court hearings. But having done that, I believe that there is an enormous potential for the future, provided we do it taking every stakeholder into confidence.
All right, so we have another question coming in. So could you please elaborate on the right to seek an insurement of personal data from the judicial virtual database once a case has been adjudicated upon? Namely, what are the views of the committee on the right to be forgotten once the data of a particular person becomes irrelevant in the database of the judiciary in terms of an online hearing?
Let me make it very clear. I don't think I can give the view of the E-committee on this, because I am the chairperson of the E-committee. The E-committee consists of a number of people. If you ask me for my personal view, there are clear categories of cases. One category of cases is where absolute privacy norms must apply. Cases involving child sexual abuse, cases involving gender violence, where you don't want to disclose the name of the victim, such as in a rape trial. You don't want to either disclose the name of the victim. There may be other cases as well. I mentioned matrimonial cases. There could be cases of commercial confidence. So you have to devise which are those categories. And it's not that we don't have those categories. We do have the categories. Your right to be forgotten raises very, very interesting issues, which perhaps, I raised in my Aadhaar dissent, and which is not the law of the land, by the way, but I did raise them when I wrote the Aadhaar dissent, and which raises very important philosophical issues, not just issues of implementation, but philosophical issues. Once a case is decided, can a litigant say that, look, though I was the product of an open court system, though the input and the output took place through an open court system, once the judgment is delivered, there should be no electronic footprint of that case. I'm not sure whether you can really say that, because before we went into electronic technology, if a judgment is reported, it's reported forever. All that electronic technology has done is to convert the reported judgments on paper, and now they're available online. So can you really say that once a case is decided, every litigant must be forgotten? Or is there a more overarching public interest in the fact that once a case is disposed of, unless it falls into a category of cases where privacy norms must absolutely apply, the right to be forgotten must be looked at perhaps differently. But I must tell you this, I'm not venturing into a final conclusion or an answer on this. You've raised a very valid point. It requires very serious reflection. And this is really something which I've just given you on the spur of the moment. It does not necessarily reflect a more considered view, which I may have to take as a chairperson of the committee.
So another question coming up. In the 2018 judgment, the Supreme Court in the Swapnil Tripathi versus Union of India judgment had allowed for live streaming of all matters except matrimonial and rape cases. is there a possibility that the E-committee would widen that mandate to include proceedings in district as well as high courts?
Live streaming?
Yes.
The principle which we have laid down in Swapnil Tripathi is not confined only to the Supreme Court. In fact, the principle in Swapnil Tripathi is that sunlight is the best infectant, is the best disinfectant. Now, if sunlight is the best disinfectant, that must apply to every judicial institution across the country. And one of the issues which is being considered by the E-committee today and by 5 very senior judges of the High Court is to frame model rules on live streaming of cases. Having said that, there are numerous issues which arise for live streaming. For instance, do you do live streaming simultaneously? Do you have live streaming with a little time lag? There are different models. The American Supreme Court, as you know, recently, if you've been watching those hearings, has been doing live audio streaming of their proceedings. That's a different model, which they have adopted. Second, who has control? What happens if something during the course of the hearing is said, which perhaps should not be said? Is there a power in the presiding officer to ensure that there may be some countermanding instructions? So a variety of issues of an administrative nature, which are being looked at for devising model rules on live streaming. But as a matter of principle, the answer to your question is that Swapnil Tripathi's precepts apply across all judicial institutions in the country.
So the clock has hit 5. Would you want to take a few more questions?
Yes, of course I can. I'm in a lockdown, so I know my secretary is not coming this evening for a dictation of a judgment.
Okay, so we have another question then from the attendee that as you've noticed that PWDs will be accessing courts and can become lawyers and judges, a person with disabilities, that is. But the Supreme Court judgments have said that persons with visual impairment can't become civil judges. How will the courts then be able to be accessible to them in such a period of time?
Well, well, let me not comment on a judgment of the Supreme Court. I mean, I'm a judge of the court. But let me tell you this, that to my mind, modern technology has been so enabling that I feel that the distinction between a person who does and does not suffer from a visual impairment has no valid basis in law or constitutional law. They're effective technological tools which would enable every aspect of legal process management, including legal information management, to be available to the visually challenged. And one of the very key features that I've been personally supervising in the e-filing module is to make sure that the visually challenged have access to the data in e-filed cases. So Mr. Ashish Shiradonkar in Pune has been talking to very talented young lawyers, one of whom is going to be working with me next year as my judicial clerk, who's a Rhodes Scholar. And we've been deriving inputs from young lawyers, ensuring that the technological processes which we follow are e-enabled, even for the visually challenged and the hearing impaired. And I'm speaking for myself as a judge, speaking for myself as a human being, speaking for myself as a student of the Constitution. I believe that we must have in due course our first judge of the Supreme Court one day who would be visually impaired. And certainly judges in the High Court, certainly lawyers, they should be able to lead lives of human dignity. There is no exception to the principle of human dignity that excludes the visually impaired under the Constitution. The Constitution applies across the board. And I think we as judges need to also understand that.
Okay, so moving forward to another question. The adoption of technology by lawyers across the board may lead to legal services becoming more expensive now. So if the cost is passed on to litigants, won't this affect access to justice to the poorest litigants? And how do we deal with such concerns going forward then?
You know, it's actually to the contrary. Technology, I must tell you this, the cost of technology is borne by the state. We don't pass on the investment which is made in terms of judicial infrastructure to the litigants. But that's one part of the issue. Far more fundamental is that technology makes processes transparent, it makes processes efficient, and it makes judicial processes accountable. It makes processes intelligible. Now, I'll give you a very simple example. We are using artificial intelligence on the SUAS platform, which has now been developed under the auspices of the Supreme Court, to ensure that judgments in English are translated into different regional languages. I think 9 or 11 now, Urdu is being added as well. 9 or 11 languages, and this is going to be increasing in due course. Now look at the impact of technology. A litigant who does not understand a judgment which is written in English has a translation in Marathi, in Kannada, in Tamil, in Malayalam, in Oriya, in Bangla, just name the language. So technology is going to be enabling for those citizens. I'll give you another example. We are now planning as part of the phase 3 of the e-courts project to ensure that the CNR number, which is attached to every case, that should also be attached with all the underlying documents in the case. So the litigant must immediately have access to everything which is filed in her or his case or their case. So technology, far from being exclusionary, would be more inclusive. There's one problem which I have highlighted right at the beginning, that access to technology is increasing. It's not universal in India. So how do we deal with that? We can deal with that by the courts doing the hand-holding. For instance, even in the Supreme Court, which is located in New Delhi, we found that, well, if we are going to implement the e-filing module, many young lawyers may not have a computer at their offices. They may or may not have a smartphone. So what we are going to do is that we are going to have data entry operators who will be appointed in the Supreme Court, so that all the lawyer does, every lawyer would get a PDF file prepared, right? All that the lawyer would do is to hand over a PDF file to our data entry operator, and the loading up of the data in the e-filing module would be done by us. So consistent as we have to be with our knowledge that technology is not accessible equally by all citizens, the courts must take upon themselves a considerable degree of the burden of ensuring that the services which we provide are accessed by common citizens. But technology is actually enabling, it's not disenabling, and it's not exclusionary.
Okay, so if you could take a few more questions in.
Yeah, sure.
What consideration, if at all, is there or planned for those with accessibility issues in terms of e-courts, for the courts and its processor in general, and for avenues such as live streaming, with respect to, and would there be a publication of the transcription of the proceedings, making published judgments and orders readable for people online?
Can you just come back with that question? Because I thought there were a lot of issues which were hidden in that question. Can I just have that again?
I'll just come again with the question, sir. Basically, talking about, this is for the people with disabilities once again.
That's we've dealt with, yeah.
All right, so moving forward to the next question.
But in that question, was there something else?
This is with respect to the making them accessible to the transcription of proceedings and judgments which are meted out by e-courts.
Okay, as of now, we don't provide for transcription of proceedings in our courts. A lot of courts across the world do provide for transcripts. Insofar as judgments are concerned, what we are planning, as I told you, the judgments must be in a machine-readable format, and they are in a machine-readable format. And more important, I perceive than the judgments themselves is also the fact that the files which are coming into the court system, the data which is coming into the court system, must be machine-readable for the physically impaired to gain access. I think we've dealt with it when I was answering the earlier question, but I just thought I'll spend 30 seconds on that.
So our next question comes in, which talks about what can bodies like the BCI do to train lawyers and prospective law students and people in the profession in order to embrace technology as we move forward?
My own perception is this, that training of lawyers is a collaborative exercise. I think bodies of the lawyers, like the Bar Council of India, the courts, we ourselves, together we have a collaborative role to play in ensuring that our lawyers are trained. I don't think either of us can say that, well, the responsibility is not mine. It's a joint responsibility because we are running one institution. We are integral elements, pillars of the same institution. The bar and the bench, we really represent two foundational pillars of the institution of justicing and the administration of justice. For instance, I just read the other day, I think yesterday, that the Bar Council of India is providing video conferencing facilities in Delhi. If the news report is right, that's a wonderful initiative which has been taken up by the Bar Council of India. And I think it's important for us to understand the difficulties of lawyers, which we do, and to deal with those difficulties in a very robust way. The answer can't be that we'll not adopt technology. Anymore, we can say that, well, we are not going to run a modern aircraft on anything but the latest technology. Judicial systems have to be run on the latest technology. Realizing at the same time the human element that is involved in the justicing process. So we have to make sure that the human actors who are the participants in the process of justicing, that they are technologically enabled. I think law colleges have a very vital role to play. The bar has a very vital role to play. Bar associations have a very vital role to play. And I think courts and the bar together in a collaborative exercise can do a lot. In fact, as part of the phase 3 and even as part of phase 2, one of the issues which I've been focusing on is the best manner in which we can train lawyers by and by to be technologically enabled, because we want our lawyers to be technologically enabled. We can't leave the burden on someone else.
Okay, so we'll do a few more questions, or would you want to wrap up?
Ahead.
Okay, sir. So, sir, another question that comes in is that currently, as we are seeing that the number of proceedings are taking place in our courts today, it seems off that lawyers with much more influence in the legal field get quicker access to reach towards the courts, or get quicker access to file their cases and present it in front of the bench. So how will this become? How does the E-committee and legal system, perceive this to become more egalitarian in the process as we move forward, vis-a-vis the rest of the people in the law field who might not be as influential as other lawyers?
Let me be very candid with you. I think it's becoming very fashionable to find an institution and start criticizing it. The tough part is when you are sitting in the hot seat and trying to make the best of a difficult situation. I must tell you that the question has a premise, which is that access is being given only to, quote unquote, people with influence. It's completely wrong. Last week, for instance, I'll give you a concrete example. Last week, when we were dealing with, 3 of us colleagues were taking up cases on video conferencing. These were cases of common citizens across the country. Convicts under 302, people denied bail for maybe an offense of cheating, somebody not granted bail for another offense. These were cases concerning common citizens across the country. This is the case of the Supreme Court. In the high courts and in the district courts, I gave you figures of the number of criminal cases which the district courts are dealing with. These are cases of common litigants. In the Supreme Court, the pattern which has been followed is this. Initially, when we began with the pandemic and the lockdown took place, and our video conferencing facilities were just being made available and were being rolled out, we requested lawyers to come with emails pointing out the urgency of the case, so that every lawyer, irrespective of who the client is, would just tell us what the urgency of the case is. The client has been denied anticipatory bail under Section 438 of the Code of Criminal Procedure. The protection which was granted by the High Court is due to end on a particular date. That is the urgency why I'm coming to the Supreme Court. Once the urgency was shown, the judge would direct listing of the case. Now I believe the stage has come when we should not focus only on urgent cases, but we must now bridge the urgent versus non-urgent divide so that we can deal with all cases which come to the Supreme Court, which obviously is going to happen by and by as our video conferencing facilities have expanded, as judges are now sitting in the court to actually take up cases. So let the young student, I presume, who said that only cases of people with influence are taken up. I would tell you from my own experience in the Supreme Court that this is positively wrong. It does not reflect the experience of the Supreme Court. It does not reflect the wide base of the pyramid in the district courts, and certainly not in the high courts as well. I have figures coming in from the high courts about the number of cases which are being dealt with in the high courts, the urgent cases, and they concern common citizens across the country.
Well, let's say we can take in a final question, which we've gotten. So it says that wouldn't the adoption of an e-courts and an e-filing lead to docket explosion in terms of the number of SLPs which would be filed? With virtual courts, a litigant does not have to bear the cost of a counsel's travel cost or cost of stay if he lives outside of Delhi. So that might incentivize a greater tendency to challenge orders passed by high courts and other courts by the way of SLP. So what's your take on this point?
I'll answer your question by looking at the flip side. Your question would indicate that many cases which could have been filed if we had a very efficient technological infrastructure may not be filed because people don't have access to justice. So look at the flip side. Yes, what you say is right, that when you make filing easier, a lot more people will gain access to justice. But look at it from this perspective, that many people who would come to the court would be people who would otherwise not have any access to justice at all. And as a judge, I don't think I'm concerned about the fact that more people will come with grievances to my court. If I have a lot of work to do, it gives you a sense of satisfaction. That's why we as judges are here to do our duties. So if our filing today is, say, X, and because of e-filing, our filing goes to X plus 15%, so much the better. Technology will enable us to deal with that filing far more efficiently. Smart management, smart scheduling of cases, smart hearings. Technology, just as technology will lead to greater number of cases being filed, and as you say, a docket explosion, technology will also give us the tools necessary for dealing with those cases.
So this question comes from a few law students who've been writing to us in the box. They've been talking about how could there be a new framework of sorts for virtual internships now that there are no physical internships possible at the various levels of courts in the country, and that's very important and significant for law students in their various years of study. So how would the various courts in the country take on that now, looking at the current pandemic?
Well, of course. I mean, I must tell you this, that, a lot of our, in fact, I have, our cases now, which are being listed before us, are coming in the electronic mode. Last week, there were paper files which were being delivered to us, but now for the next week, we have cases in the electronic mode which are being filed. So technically, a law student could read a file online. I have 4 judicial clerks. 2 of them got stuck in Delhi during the course of the pandemic. 2 of them were able to reach their hometowns in time, but they're both helping me. One of them is in Bangalore, the other one is in Patna. They're both helping me with numerous things, including, incidentally, making me more computer literate, because I was not born with computers as all of you are, and I've had to learn computers as by and by on the job. So I learn a lot from my judicial clerks. They share a lot with me. I learn a lot from my interns. And I don't see why we can't now, in the lockdown, have virtual internships as well, because there's so much that interns could be working on even in the lockdown through virtual internships. I think that's certainly something that we can work on. At least insofar as my office is concerned, I think we'd be open to that.
So I think with this, we've kind of exhausted the questions which our attendees have been putting out to us.
Thank you so much.
So on the behalf of
Nyaya for finishing the questions, not so much for finishing the questions, but thank you so much for lining this up as part of the Nyaya initiative at Nalsar. It's been wonderful to be here with all of you.
So we're extremely grateful and honored that you took your time out and spoke to us today on this Sunday evening. So we're really glad that you shared with us your thoughts about a lot of issues that are, going on in our minds right now. And although it's a very uncertain time, but we really hope that the legal system together works and we see a light at the end of this tunnel. Really uncertain, so we don't know what's next, but I'm sure that together we do work together and get to better ends. Once again, on the behalf of the Nyaya Forum students at Nalsar, we want to thank you for joining us today. And I think with this, we can.
Mustafa, maybe may I just say this? Let's convert a very difficult situation into an opportunity for change. I think change occurs in the most difficult of situations. Humanity across the world, and India is no exception, is confronted with a public health crisis of unprecedented dimensions. I think that gives us an opportunity to bring about fundamental transformations, to provide better service to our citizens, and to have a pan-India collaboration with civil society and with different segments of the legal profession to provide a good service under a robust technological infrastructure. Thank you very much.
Thank you so much. And so I think with this, we can wrap the session.